we have 3 panelists today who are going to talk about some of the research that they have done with their affiliates, and it's a variety of research. We also, as part of this panel, put together a packet of summaries of research that affiliate members have done over the past year or two, and Laura is back there and she will hand that out. It's 1 page on each, so it's kind of a quick read, but there are links and contact information if you want to find out more about it. But we are very, very happy to have with us here today Jim McLaughlin over here, and he is the, it's up on the board, Deputy General Counsel for the Washington Post, and also a member of the DC Coalition for Open Government. He's going to talk about some research, national research they did on access to text messaging. You may want to ask him questions about the Washington Post because he does all the defamation and FOIA, but he's not here on this panel to talk about that. And then we also have Dennis Hetzel, and he is with the Ohio News Media Association and also the Ohio Coalition for Open Government, and they have done, I think, some very eye-opening, but also, kind of challenging research on Supreme Court decisions in their state related to open government, which I thought was pretty courageous. And finally, we have a stand-in. This is not Peter St. Cyr with New Mexico, but you heard a little while ago from Mike Reitz, and he is with the Michigan Coalition. He's also the vice president of the Mackinac Center, and he mentioned earlier today about some research that their organization did on salary database, and so he's going to talk about them. So we have 3 very different types of research. They're each going to talk for about 10 minutes, and then we're going to open it up to questions. So why don't you guys get started? If you want to start, Jim.
Thank you, Deborah. I'm Jim McLaughlin with the Washington Post. That's my day job. I'm also a board member of the DC Open Government Coalition. I'm going to talk about some research that we did on state-by-state access to text messages under public records laws. Full credit here, I'm presenting research that was done by Helen Vera of Ropes and Gray. Ropes and Gray has been extremely generous with pro bono support for the coalition from day one. And Helen graciously allowed me to adapt the slides that she had prepared for this presentation. But really, the 50-state survey that I'm going to be talking about, all 50 states were researched by Helen. So she's really become the expert on this. So the question that we looked at was access to text messages under state public records law. Why did we look at this issue? Well, I think it's become clear over the years that text messaging is not something that just teenagers are doing, or not something that just people are doing in their personal lives. There have been a number of headlines about public officials, state government officials in particular, and local government officials using text messages to transact public business. Some of these examples may be familiar. You may remember the Detroit mayor, Kwame Kilpatrick. This was one of the earliest text messages cases, who it turned out had been conducting an affair with his chief of staff, I think it was, and the text messages in that case, I guess you could say they weren't really transacting public business in those texts, but that was one of the first sort of eye-opening cases where you realize just how frequently even very high-ranking government officials are texting. That was in, I think, 2008. In a number of other jurisdictions, including some represented here today, there have been controversies over access to text messages. So public officials, they're just like us. They text all the time. Credit to Helen for that line, because I didn't actually know what that was a reference to, but apparently there's something called celebrities. They're just like us. So that's where that comes from. I really recommend the article that Helen did on this, which was published in the ABA Communications Lawyer in June. It's really the most comprehensive resource that I've seen to the lay of the land on access to text messages. It also gets in a little bit to not just text messages, but sort of the next generation, which I'll also talk about, the next generation of communications platform, Slack, things like that. So what we found, and again, this was research that Helen did for the DC Open Government Coalition, is that the state of the law is pretty good on access to text messages. There are a few states, New Mexico has regulations on this. Texas and Georgia have actually amended their statute to explicitly include text messages or instant communications services, SMS, that sort of thing, in their public record statutes. So that's 3 jurisdictions, but by far the larger number have either recognized access to text messages under public records laws in informal guidance from the 2 state agencies, in attorney general opinions like Illinois and others, or just the statute itself, and this is really the bulk of them. The statute itself usually is broad enough to encompass any type of record, as long as it's a communication or a piece of information that's been recorded in a fixed medium, then typically, regardless of the physical form or characteristics of the record, it's going to be subject to state open records laws. So the big fight maybe 10, 15 years ago was, does this apply to electronic records? Pretty much every state, I think every state that I'm aware of, has resolved that by saying, yes, open records laws apply to electronic records. Now the question is, do the laws actually apply to text messages as well as emails? And the law, as I said, has been pretty good in saying that they do. And what really matters is the functional test. Was the record created in the course of transacting public business, regardless of whether it was on a personal device, regardless of where the record was created, whether it was at the official's home or in the office? If the person is using text messages to actually perform their job as a state official, that should be presumptively a public record. Now, where it gets harder, I think, is in practice. There have been a number of obstacles thrown up whenever people have requested text messages in virtually any jurisdiction under open records laws. Even if the principle is that they should be produced, you often see objections from the state like, we don't retain those types of records, they're not within our control, it's the person's personal cell phone, it's not a state device. Sometimes we've seen responses that they aren't fixed in a permanent medium because they're fleeting and transitory. You get privacy concerns. You know, you'll see, if you see my text, you'll also see my text relating to business. You'll also see text relating to my family, soccer games, whatever. And the easy answer to all of that, I think, is that first of all, using a state device for state business and a personal device for personal business is probably the better practice. But also, to the extent you are using a personal device to conduct state business, that's a public record. And it doesn't mean that the media or requesters get access to your texts with your wife about picking up the kids at soccer. You just don't have to produce those. But you can't just say, well, it's interspersed with that type of message, and therefore I'm going to withhold it. The practical obstacles are really the ones where this battle, I think, is going to be fought, especially retention. The possession objection, I think, can be overcome simply by pointing out that the state official has these texts in their control, and if not the state official, the provider probably has them. And so the state government, if it wants to, actually does have custody, possession, or control of the messages. Control because they can say to the state employee, we need to see these texts because they're responsive to a public records request. Retention, I think, is where we're going to actually see sort of the rubber meet the road on these types of requests, because there really isn't that much you can do if the records just don't exist anymore. And we've seen that happen in an Ohio case, in a Florida case where it was called TextGate, and at the end of a long battle, the principle was vindicated, but the texts were long gone. So going forward, I think what we can do, and I'll talk briefly about these other communications technologies, but going forward, I think it's important to make your requests explicitly encompass text messages, use of other communications platforms, any electronic communications not just emails, because we don't want to be fighting the last war, essentially, email, and have, meanwhile, the bulk of government business being transacted in other settings. And I can say at the Washington Post, for example, Slack is used, I think, by far more than email at this point. I don't know if that's true, how widely that's true in the government, but I suspect it's going to become more and more true, especially because some of these technologies make it more difficult for the public to actually obtain the records because of retention concerns, or Telegram, automatically destroys messages a certain amount of time after they're set. There have been reports that the Trump White House really likes Telegram for that reason. So it's important to make your requests encompass these things, be prepared for objections, and also just publicize, if you're in the media, cover the fact that these types of platforms are being used more often. Draw attention to it. The law is, as I said, pretty good on this, but the practicalities of it, the day-to-day fights, FOIA requests, individual FOIA requests, and individual jurisdictions are really going to be the most important thing going forward.
Guys, need a minute to get our website up. Let's see. Okay. Okay, as you heard, I'm Dennis Hetzel, the Ohio News Media Association and Ohio Coalition for Open Government. Around 2011, shortly after I got there, we realized we had a problem with our Supreme Court, certainly from any standpoint of any open government advocate. The problem was, while we have fundamentally sound open records and open meetings laws in Ohio, although death by 1,000 cuts, as we just talked about, is a problem, we thought our Supreme Court was taking the most narrow view they possibly could on many open government sunshine law cases, almost finding tortured reasons to find in favor of the government with very, very pro-government interpretations of the statutory language. And since we have elected justices in Ohio, as many states do, there's also accountability there. And as an old editor, I'm thinking, that's part, when these folks show up at my editorial board looking for an endorsement, wouldn't it be nice to have some accountability on sunshine law issues as part of the consideration that not only newspapers but citizens in general use when they make their decisions? I'll give you a couple quick examples. This is the case I would most like to overturn, and I hope to find a test case on this at some point. It's this shift of flow of taxpayer dollars to quasi-government or private entities. And they adopted a 4-part test in a case called Orianna House, which is a nonprofit organization. And then part of this 4-part test is to what degree of control is the government exercising day to day on the organization, which is counterintuitive because the reason government outsources most stuff, whether it's private prisons, charter schools, Jobs Ohio, our economic development corporation, which has very little accountability, even though it gets all the state liquor store profits to fund its efforts. The reason you outsource is to not exercise day-to-day control. We had another case involving Findlay Market, which is a public-private entity in Cincinnati. Amounts of their subleases to vendors were exempt trade secrets. The Cincinnati School Board was allowed to end run the open records law by having a post office box for school superintendent applicants so that they never had to physically handle the applicants for school board. We have an ongoing problem, by the way, with university presidential searches. The case that really got my attention was called Zadonis v. Columbus State. And I think this case is probably a good example why it's important for plaintiffs in open records cases to really get smart lawyers who are sophisticated in these areas. It was a wrongful discharge case against Columbus State, a state university, a state college. And she wanted all the emails between her and her supervisor, which would make sense in a wrongful discharge case. And the board the courts allowed Columbus State to get away with saying they couldn't search the emails by to and from, and that the request was overly broad. So I'm exaggerating a little bit to make this point, but not much. Essentially, the court said overly broad is whatever government says it is in Ohio. That was a really bad decision. The ESPN Ohio State case, where the court allowed Ohio State to use FERPA and not release records related to the NCAA investigation into Jim Tressel and the players going to tattoo parlors. Another case that made it extraordinarily hard to collect attorney fees under a kind of a loophole. It was never the statutory intent, because we talked to the people that wrote the law. And then we had a chain of open meetings cases where they took really, really narrow definitions of what's deliberate versus what's discussing in order to block meetings like, fact-finding sessions or sessions where they weren't going to actually deliberate versus discussing. So long story short, we thought we had a problem and wanted to see if our perception matched reality. So the idea was, well, let's go back. We can't go back forever, but let's go back a few years. We picked 2010, and let's build a database of all their Sunshine Law decisions, and let's figure out a way to score it that has some objectivity attached to it. Is this pro-government or pro-citizen? And there's a lot of nuance to that, and I'll talk about that in a second. This is what the spreadsheet looks like. I was really lucky that summer. I had a really, really smart intern at the News Media Association, which is paid by our foundation, our News Media Foundation, from the University of Cincinnati. And you couldn't do this with every intern, because we're not lawyers. We had lawyers ultimately review what we were going to do. And we went into LexisNexis, Westlaw, and cases we already knew about, and built a database of every Sunshine Law decision they had made since going back to 2010. And then we figured out we were going to score the individual justices. And and my feeling was, while initially, it might look a little funny, as time goes by and the database gets bigger and bigger, you're really going to see tendencies because they don't all think alike. And then after we built the database, we took it to the Supreme Court. And I think the body language was, we really don't like that you're doing this. And they really hated the idea of the scorecard. I mean, they never said that explicitly. So I am putting words in their mouth, but it was pretty obvious. But that said, they really were decent and honorable about it, and they appreciated that we didn't just dump it on them and then release it. They had an opportunity to review it, make suggestions, and some of the headings are different, some of the explanations are different, and we actually changed the scoring in some of the cases based on input they gave us on the nuances of the law. We had our own lawyers look at it, so I think we had a pretty valid process. And that's important. And there is some subjectivity, because as you know, cases are complex, and people do just read headlines, and we do try to make it clear to people that they might rule very correctly on the law, but it still might not be a pro-access decision. But that's also a flag that there's work to do in the legislature then. If the decision comes out what we would at least interpret as the wrong way. So here's what happened. In our first release, we had 36 rulings in it, and 24 were scored favorable to government. And and I can never prove this, but I think since we did this and drew more attention, we issued news releases and so on, got a little bit of coverage, made it available. Since the time we've done that, it's very interesting. In the most recent release, since 2015, there were 13 favorable rulings and 7 unfavorable rulings. And again, I can't, they would say, well, we just have better cases brought by better lawyers, and some of that very well may be true, but it's still kind of the same Republican-dominated court with pretty much the same justices. There seems to be a pendulum shift to me in which they're being not quite as rigid as maybe they were in the past. And I mentioned a couple of these cases in my earlier remarks. The open meetings email case that I mentioned earlier is really a significant one. One of the first big ones was a case involving Otterbein University that was using sworn commissioned police officers, even though it was a private university. So all their powers are derived from the state. They wouldn't release any records, saying they weren't subject to the open records law, to these student journalists. And we argued, and actually the Attorney General's office wrote a friend of the court brief in support of OCOG and the student journalists, saying no, they should follow the same rules everybody else does. Before that, students could be arrested, detained, investigated with no accountability. I mentioned the case involving access to police records of defendants that have been convicted of first-degree murder and capital crimes. A really important one was up in Strongsville outside Cleveland, where it was a school strike, and the teachers union sued for the names of the substitutes that the school district hired. And after the case, this was after the strike was over, there was some very minor circumstantial evidence of some threats, kind of minor threats. One teacher complained that maybe a car might have been pointed at him, but nothing ever really happened. The strike was over, and I think many of us in the room can think of very valid reasons why the names and qualifications of substitute teachers should be an open record, being hired by a public school district. And the court said, and I think this was kind of a breakthrough. It's one of those little cases that I think can be significant on a lot of different other cases, because you've all heard this record should be secret because something bad might happen if it's released. But there's no evidence. We deal with this legislatively all the time. We're dealing with 3 or 4 bills right now where one person goes to a legislator with an anecdotal concern, no evidence that it's ever been a problem, but yeah, we can all think of how it could maybe be a problem. And the court said in Strongsville, you got to have something. It doesn't have to be beyond a reasonable doubt. It doesn't have to be overwhelming. There has to be some evidence of a safety concern beyond just some vague concern that something bad might happen. Plus, this was after the fact. So, that's just a couple examples of some good rulings we've had. One thing I wanted to read, I do want to read this verbatim, this one paragraph, and this is in the scorecard that we create of the individual justices, which is by far, in the court's mind, the most controversial thing we do. Let me go back to that. And I do think, in fairness to the justices, the nuance is important. Whether people read it, who's to say? But some cases were included that are important sunshine law decisions but are not possible or fair to score. Cases with mixed results are not included. Votes in favor or not in favor of open government could stem from numerous factors and often complex cases. For example, a vote not in favor could be perfectly consistent with the law. However, OCOG believes the differences among judges and how they read and interpret statutes in the law may be illuminating over time. Readers are encouraged to examine the specifics of individual cases. Now, what's interesting here, too, is that now that we've got more history in this database, we're seeing some big variations. The range of individual justices is from 27% pro-open government to 55% pro-open government. So again, I think this is good information for citizens to have, and they can that's part of the package, especially in a state where we're electing Supreme Court justices. So I think you've been handed out the last press release that we issued on this. We're very pleased with the results of this. I think it's really important to kind of do your homework, be rigid, work, about how you're compiling the data, be as fair as possible and objective, and work with the courts. And I'm really glad we did it.
I feel compelled, Jim, to confess to you that while you were talking, I got a text from a public official. So now it's out there. Can't do that. Sorry. I mentioned during the state coalition reports the public employee salary database that we in Michigan put together. I wanted to talk about a couple of things, and I'll do this fairly briefly. And first, I guess a warning for all of our friends in the room here that I think there may be a coming clampdown or an effort to seal public employee information that ought to be public. But state agencies and legislatures will be very, very susceptible to concerns about identity theft and that sort of thing. So we've seen this in Washington, and I can't speak as credibly as our friend from Washington, but I believe it was the Service Employees Union put an initiative on the ballot and then spent about $2 million to seal the names of some public employees. And there's a complicated background in that one. But I would anticipate this being a wave that we see in the next couple of years, so we should be vigilant. Knowing that, the Michigan Coalition for Open Government and the Mackinac Center decided that we needed to make this information available to the public in Michigan. Public employee salaries were public, but they're tough to find and tough to compile, and you don't necessarily know what you're doing if you're an individual citizen. So we wanted to create this database, which we did. We also knew that we had to do it because the Lansing State Journal had published a database like this a couple years earlier, and there was such a backlash in our capital town. Their subscriptions dropped quite a bit over the controversy of that. So we thought we could do it and get it. We could take the hits if the hits came in. We published that database in March of 2017, and a couple things happened that were interesting. First of all, we only spent about $3,000 to do it. It was really just our staff time for constructing the website. But what we discovered was the Office of Retirement Services, which is responsible for collecting and managing the salary data for public employees for purposes of calculating their pension benefits, they had screwed up thousands of lines of data from the Department of Corrections. And so in the first 24 hours after we published this database, we were hearing from corrections officers who said, "You've got my pay at $300,000 or $200,000. I don't make that much. My wife's wondering where am I hiding this money?" So we immediately verified that the mistake was on the agency's side, not ours. We published the data as it was provided to us. But it generated a very interesting side question in the middle of some conversation about pension reform, which was, is the Office of Retirement Services calculating benefits on a false or a incorrect salary baseline? So that was one of the benefits of this project, was to get that out in the open. It wouldn't have been discovered if this database hadn't been published. If you're curious, the highest paid employee in Michigan, other than the football coaches, is a county-level community college superintendent in Detroit. And he makes $397,000. He's had increases 2 years running, and that information now is obviously very interesting of interest to many, many people. A couple of other impacts that we've had with this database that we've seen revolve around teacher compensation. Now this is a tough topic, and I think there's a lot of agreement that teachers are underpaid, or at least some teachers are underpaid. Maybe some of them are overpaid. But no matter what the view on that is, it's important to have accurate information about that policy discussion. And we've seen this cut both ways in Michigan. For example, the Teacher of the Year, the recently awarded Teacher of the Year in Michigan, hasn't got a pay increase in 3 years. And that's because of the school district's contracts and just the way they structured their raises for the last 3 years. But we think if you're the teacher of the year, maybe you deserve a raise and maybe some recognition. So that impacts teachers who might be eligible for more money. There's a very common superintendent versus teacher compensation tension that happens in communities when a superintendent is making $300,000 and the teachers are making $35,000. There seems to be some disparity, and citizens like to have that information available to them. And then, unfortunately, sometimes there are exaggerations about what teachers are actually making. We saw this in Ann Arbor, where a teacher went to a school board meeting and really lashed out at the school board for being underpaid. And he said it was an embarrassment that he was underpaid. Well, we looked at his salary information and discovered that he was making $17,000 more than the average teacher in his school district. And so having that accurate information, we think, is helpful to the public discourse. The last thing that I'll mention on this is we did work with the agencies the next time around to make sure that the information was accurate. We didn't want to get caught, republishing inaccurate data. And so, as you might expect, because there was egg on their face, the agencies that we worked with were very, very cooperative in helping us get the right information. There was some legislation in the Michigan legislature to make this mandatory for all public employees. We can only do it for the ones that have a pension, and so that's underway now. We think maybe it'll lead to some public policy change. Thank you.
Okay, I want to open it up for questions, but I can ask the first one. Can y'all hear me okay with this mic? I'm curious from Dennis how long it took to do your Supreme Court project, and did you have, how did you start? Did you already have all the cases analyzed, or did you have to turn it over?
Yeah, we, as I said, we had a really smart summer intern, and we knew about a lot of cases. We had been talking about doing this and had sort of a running list of the cases. We sent an email around to a lot of the lawyers we worked with, and then we basically dove into Westlaw, LexisNexis, and using searches and whatnot, and identified everything we could to build the first database. That took the better half a year between identifying the cases, drafting the spreadsheet, editing it, getting ready, taking it to the court, having the court go, "What? Why are you doing this?" But then working with us and very collaboratively to make it as accurate and clear as possible. So it was at least 6 to 7 months, I would say, of work before we rolled it out. And we get a little behind, but ideally we update it at least once a year, and we keep again a running list of cases as we find out about them.
Dennis, I just had a follow-up to that. I'm sort of amazed that justices were willing to have an interchange about their records. Can you talk about the mechanics of showing these ratings to the court? Are you talking about showing it to the Chief Justice? I mean, who was looking at this stuff, and who were you having interchange with? And did you have any cases pending up there at the time?
We worked with the administrative staff, and part of it is, this is my lobbyist hat on. I mean, we have generally a good relationship with them, and I kind of treat the courts like when I was an editor the way I treated the newspaper guild, is you don't catch them by surprise, and you work with them. It's part of the reality, and so we work with them on some. We have a website called Judicial Vote Counts that's really been a passion project for our Chief Justice that gets information about all these local judicial elections out to the public in an objective way, and we've been part of a group that's helped with that. So. It's like everything else. It's about relationships and a certain level of trust. And they've done a very good job, by the way, of posting all their pleadings online. This goes back years. And for the folks in Maine, I think if you should look at what Ohio's doing, and it might help.
In the Detroit or in the Michigan work, did you have charter school information as well?
That's a good question. Was there charter school information? I don't recall. I don't believe that's assembled in the same way because charter school teachers, while they are public entities, they're not part of the pension system the way traditional schools are. So I don't believe they're in that mix.
Yeah. So in other way, charter school people are kind of under the radar. They're private in that, for the purposes of your database anyway.
The source for all of our information was the Office of Retirement Services, and so if someone joined the state within a certain time frame, they get put into that system. We're now going back and filing records requests for all other levels of public employees, and so that would hopefully pick up charter schools as well.
Yeah. What percentage of the teachers would be in Michigan now are charter school teachers?
I think it's about 5%.
And on the Supreme Court rulings, that's a great piece of work. Compliments on that. Have the administrative office of the courts or the justices themselves, have they written any kind of op-eds or issued any kind of press releases of their own accord, kind of trying to put this in the context that they most want it to be viewed in?
Yeah, when we did the first round, we showed, and I should step back a second, and this goes back to Frank's question. Having been an editor, and a journalist, a pretty fundamental principle is people don't get prior approval of stuff before you publish it. And I felt this was different. They really had to be, if they weren't working with us, it wasn't going to be as good as it could be. So I really didn't have a problem with then getting what amounted to pre-publication review. And I also knew that we were going to be the last word, and we didn't agree with them about everything and do everything they suggested. But when we wrote the news release for the first release of it, announcing it, we gave them a draft and said, we'd love to have you comment, and if you have a comment that you want us to put in this news release, and they did. So and it's on the website, if you went back and looked at the initial release, you'd see that they are quoted in there, and basically their quote was of trying to, put some context around it, and really it was fine. And when we did the second release, they chose not to comment on it, but they had reviewed this before it went up.
We're just trying to get the words off of your face.
Oh.
Thanks, Dave.
On your database for that's working. On your database for from the pension or for the salaries based off the pensions, do you plan on expanding that to all the fringe benefits that these employees are getting? Because in Illinois we found that although they might say that their pension salary is $300,000, you can tack on another at least a third or more on top of that just for their fringe benefits with their private retirement. They're $25,000-$30,000 a year for health insurance, $1,500 a month for a vehicle. All of that doesn't. It's not included in their pensionable salary, but it is part of their salary. Are you including that eventually?
We haven't included that yet, although we have a different database of school superintendent salaries, and that does list both compensation and benefits.
Yeah, I had a question for James. Is there any leverage with the cell phone provider in the event that you have a government that says, well, text messages are gone and we have no record of them? Is there a way, because presumably Verizon or AT&T, those they don't just disappear, they're somewhere. And is there a way to get them from those sources?
Well, in litigation, you could subpoena them, seek them through discovery, but that would obviously require having brought a FOIA lawsuit. Short of that, I think the most that can be done is to pressure the local government agency to make sure that you're satisfied that they have actually tried to get the texts.
From the provider, yeah.
Necessary by going to the provider.
Yeah.
And sometimes there may be legal obligations on the government's part to retain certain messages, and if they're not able to come up with them for whatever reason, and it's a type of message that's supposed to be kept for 6 months or a year under the document retention policies, then that's a separate claim and a separate thing to cover as well.
I think it's fallen. I think you wanted to address that, right?
I wanted to add to the comment regarding the carriers. I think it's important to know that with respect to reaching out to the carriers, they only retain 3 to 5 days of the actual content in that text message.
Right.
So you can submit a request, and you'll get basically date stamps, times when the message was sent to whom and from. But it's important to know that, because there is a big misnomer, especially in public sector, that, and I think maybe by watching too much TV or movies, that you can reach out to the carrier and get whatever and anything regarding those texts. And it's important to know that. So, and basically that's why we're here as a archive text provider, because we work directly with the carriers in grabbing that information and retaining it, based on, as you said, retention policies. Do you want to add to that, Joe? No.
Oh, okay.
On the availability of text messages, you mentioned a rule of thumb is generally that it doesn't matter if it's a personal device or a government, so long as it's used to conduct public business. What if, as in the case of Kwame Kilpatrick, this personal activity is of public news relevance? Is there a rule of thumb for that?
Yeah, I mean, it seems like that would be public business if he's having an affair with his chief of staff and he's the mayor. I mean, I think certainly the editors in the room would argue that that is absolutely a public interest. I don't think there's you could see room for disagreement about these things, but generally if it's a high-ranking government official on government time using a government device to interact with their staff members, even if it's in an inappropriate way, that I would argue that would be in the public interest to know.
Mike, you mentioned your concern about a coming clampdown on release of public employee information over security concerns, and I'm glad that you brought that up, because one of my major concerns regarding freedom of information is a conflict with growing privacy concerns. And so I'm curious if the other panelists have, and from your states and from your experience, have similar concerns about that, and what you think we can do about it in this, because I understand some of the privacy and security concerns in this, the information age and the way that technology has changed the landscape. But at the same time, I'm certainly, advocating for the freedom of information. So do y'all have, from any of you, do you have thoughts about how to balance that and what we can do to sort of get ahead of that conflict?
Well, one thing that can be done in, first of all, some types of information about a public employee, name, rank, title, salary, have traditionally been considered public. So usually that would not be considered an invasion of privacy for the public to have that information. But you could also see lots of information about them that might be in a public file that is legitimately private. And if something is within the exemption of, I think the principle we operate under is if the substance of the information is exempt under state law, because there are substantive exemptions for certain things, disciplinary records within the government, sometimes personnel records, then it's appropriate to redact or withhold that particular information, even if there's other parts of the document that you have to produce. But that it should be based on the substance of the information and not just sort of like a blanket, we don't produce things relating to our employees.
Yeah, I mean, I think the 724 ubiquitousness of the internet is what's historically different. And a lot of people kind of instinctively have a reaction to that, especially when it's their kids, or in the case of court records, use a very simple example. It's one thing to say the files of the divorce cases are open if I walk down to the courthouse, but do you want all those pleadings, on the internet 724? And that's a reasonable, honest concern You know, we can't just be Dr. No about that. So we're going to have to get in rooms with people and come up with strategies that react to that very emotional response. We're dealing with a bill right now in Ohio. Incident reports are presumptively open and have been for years, other than social security numbers if they happen to be there, which also applies to dash cam video, and hopefully, if we succeed with body camera video. But now I've got a bill based on one constituent going to one legislator that if there's a school bus accident, this fellow discovered his child's name was in the accident report because his child had a minor injury. Well, of course, journalists know how important that information is for the reporting process. Not that you won't find it on anyway, maybe on the family's Facebook page, but it's going to be harder, and the police are the most accurate and credible source of the information. But this guy was appalled to find out, mainly that the Highway Patrol, which they post those reports online, and all of a sudden his kid's identifying information with address is on the internet 7/24. So the reaction to that, and I don't know that we're going to succeed in stopping that bill, which is going to be a precedent for starting to shut information out of incident reports. But the reaction of parents and legislators to that is very understandable. So I don't have brilliant answers to this, but I think we've all got to really think of clever, smart public policy strategies that deal with the unique character of 7/24 information.
One other, I'm sorry, did I interrupt you?
No, that's it.
Okay.
Sorry.
One other thought in answer to your question. I agree with what Jim said as far as some information about a public employee not being of public interest. And I think we have to be sympathetic to those differences. Any of us that are employed by a nonprofit in this room, many of our salaries are publicized. They have to be filed with the IRS, and that gets public. So we can sympathize. We knowing that there could be potential backlash from public employees when we first released this database, we actually went out and interviewed a number of them and received very, very warm testimonials from people saying, I'm a public servant, I get that this is public information, I endorse this, and that helped us navigate some of the feeling that this might be a personal attack on people.
Frank Gibson with the Tennessee Coalition. Jim, in your research, did you find any particular state or city that might be a model for solving this problem, where it worked particularly well?
Well, Illinois has a very good attorney general opinion on point. I forget whether it came out of Chicago, but there's an Illinois AG opinion that's helpful. There is some good case law in some of the jurisdictions, and Texas actually has, as I said, has amended its statute explicitly to cover text messages. So that would be Texas, New Mexico, and Georgia would probably be the three that are the most forward-leaning in that regard.
Yeah, back to the salary issue, you mentioned compensation, and the subject of benefits comes up. I view them as one and the same. In Illinois, we have a lot of elected officials that serve without compensation. And when we FOIA'd park districts, for example, we found they all had free golf passes, free aquatic passes, and those were actual benefits, or school boards that were catering in their meals. College of DuPage is an example, and the IRS said that's a benefit. That benefit is compensation that's not tax-free and made them pay tax on it. So we've crafted our FOIAs, when we talk about salaries, it's to include what they may call benefits, which are in fact compensation. I don't know if you've ever run into that with other states, but we run into it a lot in Illinois.
Yeah, point taken. Sometimes when you FOIA for someone's salary, sometimes the records that agency keeps, they don't have the benefits at the same time.
A comment on Jim's presentation and a question for Dennis. I think it might be useful to point out that you certainly gave appropriate credit to the law firm that did the research, and many of the coalitions have outside counsel do pro bono litigation for them. But in D.C., we've found for now 5 or 6 years that we've gotten some outstanding research done. It's a large firm, and they have a lot of summer associates, and they love doing work for the coalition because this is white hat public interest, getting them into some public policy issues. And so we've had, the messaging, we had the body cam was mentioned, we had, I guess, contracting now going on. So that's just something that the coalitions can keep in mind. Law firms, especially the large ones, can provide really useful assistance that doesn't involve litigation.
And the associate can get an authorship credit out of it, as she did
Right,
here.
and it's good
So
for
that's
them
another
too
thing you
because
can
it's a
sell.
publication, et cetera, and you assisted in getting it published, so that was helpful. The question on the scorecard for judges is, I think we worried about this in election time from time to time, that nonprofit coming up with a scorecard for an elected official. How do you, since judges are elected officials, are you not a nonprofit association?
Yeah, the OCOG is a 501c6.
Okay, so
It's a gray area. I mean, to be honest, I think we're scoring based on the decisions making. We're not making it's objective as objective as we can make it, and we're not endorsing people. We're not saying you should vote for so and so because he votes this way. This is objective, information as objective as we can make it. So I think that would be the argument as to why it's okay, and no one's questioned it.
You also mentioned judges coming before the editorial boards during their election swings. I mean, do you use, is this information something that's brought up in discussions, or that you're promoting to have discussion with judges to sort of use it as a, why are you scoring so low on, favoring public disclosure? I
mean, I think that's something that's up to the newspapers on an individual basis, or any other citizen group, if they want to use or not use that information. But it's out there. It's out there for them. We make it known that information is there, and then it's up to anybody, any organization. The example I use, just because when I was an editor in Pennsylvania, for example, that would have been interesting information to have, when the judges came through.
Thanks. This is a question for Jim. It's a little bit tangential, but so in Missouri, we're seeing what a lot of states are seeing, with governors starting to use Facebook as a platform for reaching their constituents more. Our governor holds all of his public town halls on Facebook, right? So we requested the list of everyone who's been blocked from the Facebook because that limits your participation, right? And of course they said no. So we're appealing. And so I'm wondering how that factors in. They're also starting to talk about it as if it was metadata, which I don't think it is. But is there any sort of, how does that work? Is there any sort of, have you seen any sort of rulings anywhere else, or?
Well, social media postings would be considered records, I think, under...
The postings are, that's clear by an attorney general's ruling, but they're arguing these aren't postings.
Oh, I see. The actual selection of whom to block.
Right.
Yeah. I know there was a lawsuit somewhere, I forget what jurisdiction, about like a First Amendment challenge from someone who had been blocked by a public official. Whether there's a public records angle to that too, that's an interesting question. Yeah.
Yeah, that's my lawsuit, but it doesn't have, that lawsuit doesn't really have a public records angle to it. It has, as you note, it's a First Amendment public forum doctrine claim. The claim being that the president violates the First Amendment by blocking people based on their viewpoint. It had, the issue that you raise hasn't come up yet in our case.
Any other questions? Okay. All right. I think we moved lunch to 12:15, but thank you, panelists. It was a great presentation. We appreciate everything.